Good morning. Actually, this case which I am going to refer is most important because nowadays even small vendors used to export the goods to foreign countries because of our heavy populations migrated to other countries, particularly Gulf and other nearby countries. So their day-to-day need is being supplied from here. For all those things, so many formalities, bill of lading, shipping bill. Apart from that, the process were there, customs checking. Apart from that, there is an other authority called Export Credit Guarantee Corporation, ECGC Limited. For this purpose, what had happened actually, the appellant, one Harris Marine Product, they used to export fish meat and fish oil. The respondent was government company ECGC under the control of Ministry of Commerce and Industry, Union Government. They provide range of credit risk insurance cover to export. So the company Harris Marine Product paid a premium for bearing policy number. Thereafter, the policy was for 2.45 crores. The vessel Tiger Mango Voyage set sail on 15/12/2012. The bill of lading was prepared on 19/12/2012. The date on board, but vessel commenced loading goods in question on 13/12/2012. The vessel delivered the goods on 22/1/2000. The overseas buyer defaulted on payment. The appellant then lodged his claim. So that was rejected. They simply say for containerized cargo, the date of onward bill of lading, which is present case for 13/12/2000. This was just a period to the effective date of policy, 14/12/2002. So therefore they did not grant it. But the Supreme Court, by referring rule of contra preferendum. So for that purpose only, I want that those who are preparing for examinations must understand the Contract Act, wherein the doctrine of contra preferendum is being used. So many judgments were discussed. They say it is entrenched in our jurisprudence that an ambiguous term in insurance contract to be construed harmoniously by reading contract in its entirety. If after that no clarity emerges, then the term must be interpreted in favor of the insurer. This is called contract of contra preferendum. So finally they set aside the order of the ECG, NCDRC. So against they prepared an appeal that was rejected. Therefore, the order was rejected. ECGC rejected. Therefore, then they preferred NCDRC for compensation. Then the impugned order they have rejected. That was set aside. Accordingly, impugned order by NCDRC hereby said. The appellant complaints consequently allowed. ECGC is directed to pay claim of 2.44 crores with 9% interest. So how this case would help you? AIR 2022 Supreme Court 3036. AIR 2022 Supreme Court 3036. Harris Marine Product Export Credit Guarantee Corporation. How this case will help for other cases, you must understand In RR case, insurance are being followed. Lorry receipt also insurance is being paid. So during that period, if any date of policy and date of delivery, date of loading is disputed, you can, even though your policy was not there prior to the loading, but after premium is being paid, the cargo is transported. The logical conclusion of the Supreme Court, Apex Court, in AAR 2022, so 3036 was, once you accept the premium, insurance premium, only for payment of the goods being delivered at a foreign country. So that if it is not done, you can claim. This is the way you can also claim in the other transport carriage of your goods being delivered, whether you want other similar corporation to regulate all those things. It is up to you to approach your Chamber of Commerce for facilitating these facilities. So this judgment is referred only for not only for exporting goods, but also for the term harmonious construction, law of contract, rule of contra preferendum. So that is most important if you are appearing for or preparing for district judge examination. Best wishes.